welcome to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created, as we say, to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources to help you decide whether or not you actually do need a lawyer. Perhaps we'll help you determine how you might be able to handle some issues yourself. If you decide that you do need to consult with outside counsel, you'll be better prepared, and as a result, so will they. Our goal, of course, is to help you achieve the best possible results, hopefully save time and money, and have those better results. So the Bazar and Associates law firm in East Providence continue to donate their time and their expertise on the various issues that we tackle. And we want to thank, once again, attorney David Bazar. Thanks. So today, what we'll tackle, we're going to have a discussion about trials by judge and by jury. In the news recently are stats that indicate that the vanishing of criminal trials by jury. It's so pronounced that it's made the news. It was first recorded as a noteworthy incident in New York in the Southern District, which pertains to Manhattan. But apparently it's everywhere. So what exactly does that mean, and how does that affect your life if you should be facing a trial, criminal or otherwise? If you have that choice, what might better serve your needs and why? If you remember your high school civics class, there was a value in having a jury by your peers, and that is supposed to be a fundamental right of the Constitution. Why are people deciding to do it in some other way? What about that participatory democracy? And so what should we consider? So David, if there are fewer and fewer trials by jury, I guess we need to discuss that. But first, help us go through a little bit about, or a quick primer on, civil versus criminal trials. Who gets to have a judge versus a jury, and how do they get to determine that?
So there's a lot of questions that you asked in that little segue there.
Take it away.
Okay. So there is a constitutionally protected right to a trial by a jury in certain circumstances. And so let's distinguish between civil and criminal as a starting place. Some civil cases, you do not have a right to a trial by a jury. It depends on what type of case it is. Certainly, a claim for what we call equity in a civil case is not a case that would be tried in front of a jury, but rather in front of a judge, because you're looking for equitable relief, not money. And there's a distinguish made between that type of case and a case tried at common law or at law. So criminal, obviously that's a charge brought by the state or city or town for you doing some violation of some criminal statute or ordinance. Civil is someone usually suing you for money or for some civil relief based on something that you've done to harm somebody or perhaps hurt somebody in some way or another, with your actions. So equitable relief is an injunction usually. I'm doing something on my property, you want me to stop doing it, so you bring a suit for an injunction. That's a suit for equitable relief, no jury in that instance. However, if I have you come over to my house, I have been negligent in some way in maintaining it, and you get hurt and you want to sue me for your injury, that's a claim for damages, for money, which you would have a right to a jury trial in the first instance.
So is there ever an occasion where you, as the person who's been accused, would rather have a jury trial, but you can't have it? It's denied to you, even though you were supposed to be having that option?
In a civil case?
Yes.
So in a civil case, depending on where you bring the case, if you're bringing the case in district court, small claims, that type of thing, you waive the right to a jury trial by bringing the case there. In a small claims case, you actually sign a form saying that you give up your right for a jury trial and your right to appeal for a trial in front of a jury. In a district court case, you can appeal if you lose, and you may have the right at that point in time to ask for a trial by jury, depending on the type of case. In Superior Court, like I said, if it's something where you're suing for equitable relief, for injunctive relief or something of that nature, which were different courts in England. And remember, our law is based on English law, and so a lot of what happened in England flows over to our Constitution and to our rights. So if you have a case that at common law you had a right to a jury trial for, then you do have the right to the jury in that case as long as you claim it.
Okay, so in setting this topic up for today, the reports were across the board. There are far fewer cases in recent decades, not just this year, but in recent decades that are going to jury trials because prosecutors are increasingly negotiating plea deals, and it's a trend now that some might say is disrupting the foundation of the American judicial or justice system.
Okay.
Comment?
So two things. Criminal cases, which is what you would be referring to there
in this case,
with
yes.
prosecutors.
Yes.
You have a right to a jury trial, and you do not have to accept a plea bargain. You can say, nope, I didn't do this. I'm not going to accept even the best offer that you're giving me, which would not even result in a conviction, because there's still something that you've offered me that's on my record, and I want to be vindicated and I want to go to trial. So if it's a misdemeanor, you know the difference between a misdemeanor and felony being the severity of the penalty. So a misdemeanor is a case that has imprisonment of less than 1 year and a fine of up to $500,000, whatever the statutory threshold may be these days. And that's brought in district court in the first instance. You have to sign a form which says that you waive the right to a jury trial in the first instance. And that's whether or not you plead or you want to keep the case in district court. Most people will usually keep a case that's a misdemeanor in district court in the first place because you have the right to have the case tried in front of a judge. And if you win, that's the end of the case. Criminal, we're talking criminal cases. And if you lose, then you have the right to appeal to the Superior Court for a trial in front of a jury if you wish to have the jury hear that kind of case.
And if you have the appeal and it's going to the next level, you also have an option then to just have the judge bench trial?
You can. The right to a trial by a jury is usually the defendant's right. Mm-hmm. So the defendant has the right to waive the jury aspect of a trial. So again, when you appeal the case from district court and you, if you've lost, you get what's called a trial de novo, which means brand new.
Brand new.
And you have the right to say, yeah, I want a jury on this case this time, or you can say, no, I waive the right to a jury, I want a judge to decide that.
Okay. So if recent decades and in recent years, there are more and more judges saying, I've been sitting here, but there's not been a criminal jury trial. One judge is claiming in New York, in his 4+ years on the bench in federal district court in Manhattan, it was the judge's only criminal jury trial in 4 years because more plea deals were taking place. Another half a decade had 4 criminal trials. What would you like to say about the trend, that kind of trend, David?
I don't think that that's necessarily the case in Massachusetts or Rhode Island. I mean, there are less trials, that's for sure, especially, civil cases, because there are more alternative dispute resolution methods available on a civil case. And we've talked about it in the past. You can mediate a case, you can arbitrate a case, you can take the case out of the system altogether and have it tried privately if you want. There's a lot of different ways for cases to get resolved, including just settlement discussions and negotiations. So many, many, many more cases resolved today, especially, I say, on the civil side than they used to. True probably on the criminal side as well. But if the case, the only thing you can do to negotiate a settlement on the criminal side is negotiate a settlement. There aren't really alternative dispute resolutions available for a criminal case. You're not going to arbitrate the case and resolve it that way. Mediate it, I mean, perhaps a judge in some ways is mediating it when he or she sits on a pretrial and discusses the case with the attorneys. But the long and short is it's really a negotiation. Call it a plea bargain if you want, or a plea deal, or whatever you want to call it. But if both sides come to the conclusion that it's better for the state to accept something less than they think they can get at trial, and it's better for the defendant to accept some offer than to go to trial. A lot of those cases will resolve.
I think we need to flesh that out a little bit more, but when you hear judges saying that they think it's such a loss, it's not a miscarriage of justice, certainly, but certainly it's a loss that these aren't being heard by juries, rather decided by judges, or never having it see the light of the courtroom, rather just done by the back room. I don't mean it to be the back room, but in fact just being pled out. Thank you. So any real loss in your estimation by having things not see a courtroom?
It depends. Individual case. If I have a client who says, I don't want to go to trial, I don't want to spend the money for trial, I didn't do this, but I will accept some form of punishment that doesn't send me to jail or doesn't affect my record for a long time, I will take that plea to resolve the case. I think there's a loss there because somebody's taking responsibility for something that they didn't do. I don't like that, and I can't, I mean, as an attorney, all I can do is counsel my client and give my advice, but if they didn't do it, and I know they didn't do it, and they want to say, you know, that they'll accept responsibility, there's very little I can do as their attorney, or any attorney, to stop them from doing it, because they could just let the attorney go and do it on their own. And so I think there is some loss if someone feels that that's their best option rather than going through with the trial and being vindicated. And again, of course, it depends on what they're accepting as the responsibility. On the other hand, more cases that are settled are probably not a bad thing, because there's still a number that are getting tried, and it lowers the weight for those people who want to go to trial, and it gives the court a better handle on the volume of cases that are going through there. So, and in a civil case, I've always told my clients a settled case is a good case.
Good to know. Legal experts, apparently from your bar associations these days, are saying that this overall national decline is primarily because of an advent of congressional sentencing guidelines. Of course, there are bills out right now to reform some of these things, but an increased use of mandatory minimum sentencing. So we've had terrorist attacks and people accused, and many would say, I'm better off taking that plea because I'll have a guaranteed minimum, but if I have a jury, go to trial, there may be enough people who really don't want to hear this and certainly aren't at all sympathetic, and I'm going to have even a worse outcome, almost as if no option at all.
So you're talking federal court.
Federal court.
And federal court, you're correct, has the sentencing guidelines, and built into the sentencing guidelines is some deduction in the amount of time that someone might have to serve if they accept responsibility, which means pleading out. And so I do tend to agree with you in this sense. It's sort of like incentivizing someone to plead to something that they either did or didn't do, or the state may or may not be able to prove, to get a reduction in sentence, which sort of does cut away at, what about my right to a trial? And why, by asserting my right to a trial, should I be penalized in the sentencing phase if I happen to lose? So I can see that argument. So when there are prosecutors that they are saying that now that it's transferring an awful lot of power to the prosecutors and discouraging defendants from getting trials and so on and so forth, is there an issue, or what do you think of the issue about the fact that in some states we have elected prosecutors, attorney generals. In others you have elected judges. So not saying that any particular AG or any particular judge has a problem being impartial or wanting to have more on his caseload that says he's such a swell person and ready for re-election. Do you think that tips the scales unfairly, or in a way that just doesn't have a good carriage of justice the way it should? Well, First of all, on the appointment of judges, I think electing judges is really the worst way you can go, because it does bring politics into what needs to be an otherwise impartial setting. And you know, you can have good judges elected. I'm sure that's the case, and I'm sure there many are. But so many different things can come into play in even the appearance of impropriety given that system. So I think the appointment of judges with a lifetime appointment, or at least a term that's reviewable or whatever, is much better than electing judges. I don't think that the election of judges necessarily plays into what a judge may or may not do for most cases, but I think when you get some highly politicized cases that are in front of that judge, that may tip the scale one way or another, where it shouldn't have anything to do with how the judge looks at the facts and approaches the case. So I do see that as a problem. As far as the prosecutor goes, I don't see that as much as a problem. A prosecutor is supposed to use his discretion in how cases are determined, whether they're going to be prosecuted or not, and that type of thing. But the prosecutor has a lot of power in deciding who's going to be charged and what cases are going to be brought. There's no question about that. But I think in the end, as far as our judicial system works, it's the judge who needs to be the one that stands above the fray and has all of that independence and freedom to do what's right.
Good point. And of course, with that AG, almost in any situation, no matter what way the AG decides to take this, his political opponent is likely to criticize whatever did or didn't work out that he could possibly use against him. So that's not a stack deck, but certainly it makes it more political than it should.
Yeah, it definitely plays into it, and it's definitely campaign fodder for an opponent to say he didn't prosecute this case. Why? Is that guy too politically connected? Whatever. Or he did prosecute this case and he shouldn't have, or he lost this case and he shouldn't have. Well, you know, the losing of the case really isn't as much to me as a political issue that can be raised, because the prosecutor does his best to try the case and bring the cases, and he's got professionals working in his office to do that.
Right.
You can't blame someone politically for the whims of what a jury might or might not do.
We've talked at times about some people who choose to represent themselves. And so we'd like to present some information that maybe someone might need. If someone decides that they're going in a criminal situation, they, for whatever reason, decide to represent themselves, are they better off choosing to have the bench, the judge, versus the jury? Pro and con?
Well, you know, it's the same issue that goes into whether a lawyer wants to determine whether or not it should be tried to the judge or to a jury. So starting with the decision in the first instance as to whether you're going to use a judge or ask for your jury trial, it depends on the type of case it is. It depends on the issues that you're looking at. And again, we've got civil versus criminal. If it's a very complex civil case, you might not want to have that tried to a jury if you have a judge who's got some expertise in a particular area, securities and exchange type of cases, whatever the case might be. So there are some reasons on the type of case where you might decide, you know what, this really isn't a great case for a jury to try to decide it should be tried in front of a judge. As a pro se litigant, the judge might be a little more lenient on you if there's no jury to hear your mistakes on trying to get evidence in front of the jury, because the rules of evidence are designed to do is to make sure that the jury doesn't hear evidence that the jury shouldn't hear. So if there's no jury, the judge will often say, I can separate the wheat from the chaff, and so I'm just going to let things in that might not otherwise go in, but I know what to listen to and what not to listen to, what to look at and what to ignore. So it might be easier for a pro se to try a case in front of a jury, but again, as a pro se, you're making a lot of fundamental mistakes doing that, because your case may be one that's better off tried to a jury, and you're handcuffing yourself by trying to do the case yourself.
Well, if you are pro se, representing yourself, a judge isn't going to expect you to have opening remarks, although you might. Is that true?
Well, I would say that most judges would hold you to the same standard that he would hold any lawyer to, and you're going to be expected to know the rules and know what you're supposed to do and follow the procedures. And so if you don't have opening statement for the judge to hear, if it's being tried just to a judge, you may be giving up again an opportunity to convince the judge or sway the judge in your favor. And so, again, that's one of the risks of being a pro se litigant.
Juries, you can sometimes pull on their heartstrings. They go by their feelings, even though they are challenged to weigh evidence and facts. Mm-hmm. They have feelings. That can go for or against. If you have someone who's speaking on his own behalf and he is a compelling storyteller, judges are likely to sift that out in 3 seconds and understand that this is hand-wringing, not facts, and this is what I have to evaluate. Not so much, perhaps, with a jury. If he is a good storyteller and has, I don't know, extenuating circumstances and wants to plead, that could be a large factor, do you think, in someone's
Sure.
determining whether they want to go to jury or to judge?
Yeah, and again, it always depends on the facts and what needs to be put out in front of a judge or a jury to get the best finding that you can get. So if it's a defense of a criminal case, for them to be able to find you not guilty. There are cases where someone who's very smart and articulate and, as you say, a good storyteller might be able to convince a jury of the situation where a lawyer might not be able to get across all the things that you're saying, because if it's your character that's at trial or something about you that's at trial that you can convince the jury of otherwise, and you're really good, I would say that's probably 0.00001%
yes.
Of cases where that's the case. But is it possible? Yes, it's possible. Remember, in the law, though, we deal with probability, not possibility, for the most part.
Good point. So not talking about pro se, you're representing yourself, but you're representing someone. If you're representing someone and you know that they are guilty, but they have a good story, are you more likely to, what's your probability, what's your way of evaluating that, David?
You cannot allow, as an attorney, anybody to testify untruthfully. So no one can go up and tell a good story that you know not to be true, and you be a party to that. So if you have a client who you know wants to testify and you know won't tell the truth, you have to, you owe a candor to the jury, you have to withdraw. And you can't tell the judge why you want to withdraw because you have an attorney-client relationship that you have to protect, but you have to make sure that the court knows that you can't participate in whatever is coming from a testimony of a client or a witness.
And to continue that, would the jury, if there is to be a jury, would the jury know that an attorney has withdrawn himself from this defendant? Even if they don't know why, will they know that?
Yeah, well, I think they would know that, but I think a judge would be very careful to make sure that it doesn't affect the fairness of the trial.
Okay, and our guests, our viewers need to hear this too. So suppose you have someone who is innocent and but there is weak evidence on the side of the prosecutor and you figure you can shoot holes in it. Are you likely to want to have the judge or the jury? He's innocent, there's weak evidence.
It depends on who the judge is.
Okay.
So there are certain judges that you as attorneys have worked with and know, and you know.
Please tell me it's not your roommate.
No, no, but it's, you understand where these judges have come from, their backgrounds, what they're more likely to be swayed by. And if you have a judge that is really fair to defendants, you might want to go in that direction. If you have a judge that's a little more difficult and not so easily swayed in the favor of a defendant, perhaps a judge who is a former prosecutor, just saying, doesn't necessarily mean that that's going to be how they are,
okay.
You know, a jury might be better in that instance. So here's the thing, and this is why pro ses really shouldn't be trying jury trials or trials at all. Very complex trials, oftentimes, you probably know this, lawyers may use jury consultants in very big trials because who sits on a trial and what's going to sway a jury. When we prepare a very large case for trial, we'll often do focus groups with people who are sort of like our mock juries to try to determine what evidence is going to sway them, what evidence doesn't move them, what part of the story is meaningful, so you know where to concentrate your case, and what type of person is most likely to be favorable to your case. So,
you being the defend.
well, I'm
defending.
talking civil cases for
Okay,
me,
civil, okay.
and those type of instances. Maybe in a big criminal case with enough resources, you might do that. I wouldn't be surprised if, you know, well, you know these kind of cases that have been out there that are very well-known cases where the lawyers look for a certain type of juror on their jury panel because they know that's going to be more persuasive for their case, someone more receptive to it. So the same thing is true of judges. So you need to have experience in the whole system in order to understand where your best case is likely to be presented.
I think that those are good points. Of course, some would easily say too, I'm sure that Marcia Clark with O.J. Simpson thought she had picked the right people to serve, but you don't always know.
We often, as lawyers, second guess ourselves on those types of situations, but that's exactly what I'm referring to.
So if you are not going to have a jury, then you don't have to worry about jury selection. Is there more cost to a person who is being criminally charged? Is there more cost to having a jury case versus a judge?
I wouldn't think so, because the same preparation has to go into it. Although, if you're in a case with a lot of resources and money's going to be spent on a jury consultant, well, you do save some of that money, but given the type of case that might be, it's probably not a big percentage of what you were going to be paying anyway.
What about depositing jury fees if someone's dealing with that? What does that pertain to, David?
I don't even know. What is it?
I've never heard of deposit. Of all the things that I've researched, depositing jury fees was not something I've ever heard. So I guess if you haven't either, I'm not going to worry.
Yeah, I've never heard of it. The only thing I could think of is that when you get paid to be on a jury, you deposit your check, but I don't know what that means.
Okay. So we were talking about plea deals and that there are so many that seem to take that route, and of course it takes out of the equation jury or even at times the judge. When someone, as you said earlier, might not be guilty, if someone is not guilty, does that say that there's a problem when you have them taking a plea deal if you know that they're not guilty? What does that suggest about the American judicial system, that they'd have to go that route? Do you think that that's something working
a lot of
well?
the times what's asked is by the judge when you're doing a plea is listen to the facts that the prosecutor is going to present and tell me if you agree with those facts. So you plead nolo, which means no contest. You're not saying I'm guilty. And as long as the facts can form a basis for the judge to impose a sentence and you can accept enough of the facts, that's what you're doing. Again, remember I said I don't like people just taking pleas just to do that, so I would never recommend to my client, yeah, just say yes, that's true if it's not true. You can't do that.
It's good to know. Well, we've certainly covered quite a few options here. We hope that this has helped your understanding if you should have to be faced with that kind of choice. Please stay tuned to the Law Matters because, as we say, the law matters to you.